Good afternoon, everyone.
Good afternoon. Hey, Judge, I'm having a issue with my software. Just give me 1 second before going
Sure,
live.
not a problem,
Thank you.
ma'am.
Good afternoon, Judge.
Good afternoon, Your Honor.
Hello, everyone. Let me know whenever you're ready, Miss Smith. We're not in a rush.
Okay, it's pulling up now. Okay, Judge, I'm ready to proceed.
Okay, thank you. And just to make your life easier, I'm going to formally call the case so you know we're on the record.
Thank you.
This is going to be a hearing in an appellate matter. Kieran, I hope I'm pronouncing that right, Kimbrough versus the City of Atlanta. Case number 25 CV 006226. If I could get announcements from the parties for the record, starting with counsel for Mr. Kimbrough.
Yes, ma'am. My name is Ken Davis, and I'm counsel for Mr. Kimbrough. And I apologize. I've been under the weather a few days, so I don't have quite full faculties in my voice, but I'm going to do the best I can.
Okay. And who do I have here on behalf? And I see that Mr. Kimbrough is also present and observing the
Yes.
proceedings.
And
And then who do I have here on behalf? Anyone else for the plaintiff?
yes, ma'am.
Yes,
Yes,
ma'am.
Your Honor. We also have Michael Smart, who's another attorney in the office. It's kind of here's my alternate voice.
Good afternoon,
Okay.
Your Honor.
Good afternoon, Mr. Smart. And then who do I have on behalf of the city?
George Prothero, Your Honor. Good afternoon.
Good afternoon, Mr. Prothero. Seems like we've been seeing a lot of each other lately.
I was thinking the exact same thing.
Okay. And do I have anyone else here on behalf of the city?
No, Your Honor.
Okay, excellent. So as I mentioned when I first called the case, my understanding of this matter is that I've reviewed the record such as it is. My understanding is that Mr. Kimbrough was a police officer who was involved in an incident with an individual who sadly died as a result of an interaction that Mr. Kimbrough had with that individual. And I'm not meaning to characterize that in any way other than that they are timely connected. And that as a result of that incident, the city took the position that Mr. Kimbrough had violated an APD policy regarding, I believe, seeking prior permission or permission from a supervisor on scene before attempting an arrest of an individual. And that as a result of that, the chief of police, Mr. Shirebaum, which I also hope I've pronounced correctly, made the determination to terminate Mr. Kimbrough from the Atlanta Police Department. Mr. Kimbrough filed an appeal through the appropriate process or sought review through the appropriate process, and that decision was affirmed. And then the next step was to file the instant appeal. That's my general basic understanding of the positions the parties have taken. If anything I've said is incomplete in a meaningful way that you need to educate me about more facts, please do. If anything I have said is incorrect and you need to make sure that I have a correct understanding of the facts, please feel free to correct me. With that, I will hand it over to Mr. Davis or Mr. Smart, whoever I'm going to hear from on behalf of Mr. Kimbrough.
You'll hear from me in the beginning. And Your Honor, I apologize. I have not done one of these hearings. Would you like for me to go ahead and give our entire argument at this point?
Yes.
Okay. All right. Very well. So as you noted, and I think your facts were absolutely correct, we did file for this petition on May 7th, asking the court to review the decision of the Atlanta Civil Service Board. It is our contention, which was in the pleadings, that there were several errors in it. First, we conclude or we contend that the decision was made without sufficient evidence. We contend that the board exercised an abuse of discretion in how they came to their conclusion, and also contend that they had an erroneous conclusion of law that we think affected the decision. So just to kind of reiterate some of the facts, as you indicated, this petition for review arose out of a highly publicized incident that occurred on August 10th of 2023. Officer Kimbrough responded to a minor traffic accident that involved Johnny Holloman and another motorist. Kimbrough determined that Holloman was at fault, and he wrote him a citation for the traffic offense. When presented with a citation, along with an explanation that his signature was not a statement of guilt, along with court date and time, Mr. Holloman became argumentative, refusing to sign the ticket. At that time, Officer Kimbrough, we would contend in compliance with state law and RAPD policy, decided to detain Mr. Holloman. And the use of the word detain here is very important because there is a distinction between those two things, and that's the distinction that I think this whole case actually rests on. So once he decided to do that, Mr. Holloman physically resisted him. The struggle ensued. Officer Kimbrough ultimately employed a single use of his taser to bring Mr. Holloman under control, but unfortunately, and very sadly, Mr. Holloman became unresponsive and was pronounced dead early the next morning. So following this incident, the Atlanta Police Department, the Atlanta Police Department, their Office of Professional Standards, launched a thorough investigation into any potential policy violations by Officer Kimbrough, and not just Officer Kimbrough, but other officers who'd responded to the scene in the aftermath. At the conclusion of that investigation, OPS exonerated Officer Kimbrough concerning his use of force, and noting that Holloman's resistance and other factors, and then found unsustained, meaning there was not sufficient evidence to either exonerate or sustain a violation of APD's traffic policy.
Mr.
That
Davis,
states that a physical arrest for refusal to sign a citation must be approved by an on-scene supervisor. It's the policy you mentioned.
Mr. Davis, just quick question to help me
Yes,
understand.
ma'am.
Where does the Office of Professional Standards fit in the decision-making process? Because if I understand correctly, the facts are that OPS made this decision, but then is it that Chief Shirebaum said, no, I don't agree with that, I'm taking a different step? And what is that process? What is that flow supposed to look like?
Yes, Your Honor, that is correct. And there's certainly nothing in policy that prevents the chief from doing that. The way that works, OPS makes a recommendation. It goes up the chain of command for either approval of the recommendation or not. And in this case, as it went up the chain of command, it got to Assistant Chief Tyus, who did not agree with the findings and instead wanted to impose dismissal. Now, I would like to explain a little bit about why the OPS decision was what it was. They interviewed Mr. Kimbrough. They also looked at all the facts, and they determined that, well, in his interview, Officer Kimbrough indicated that he was attempting to detain Holloman until a supervisor could get there. That he was going to detain him, then call a supervisor, and would be within compliance of the policy. And of course, the law allows him to make such a detention as well. Unfortunately, that's when Mr. Holloman resisted the detention that led to the use of force that ultimately and sadly led to his death. So,
And is Mr. Davis, am I correct that the reason that Mr. Kimbrough consistently argues that this was not an arrest, it was a detention, is that if it was only a detention, and if that is a distinction with a difference, that the policy that the city says Mr. Kimbrough violated was the policy requiring him to have permission from an on-scene supervisor before he arrested
that is correct.
Holman, is that right?
That is correct, Your Honor.
Okay, thank you, Mr. Davis.
And in fact, in the OPS report, they note that there is no policy that requires an officer to have a supervisor before they detain a suspect. But this traffic policy does require, a supervisor before an arrest. So after this investigation, once that recommendation came up, when it went to Chief Tyus, he, as I mentioned, he disagreed with the findings, but he made no explanation of why. Nothing in the record says what he used and what he determined to distinguish between what would have been an arrest, which would have been a violation of policy, versus what would have been a permissible detention. He doesn't indicate that in the record. So his recommendation, of course, goes to Chief Shearbaum, and Chief Shearbaum complies with that recommendation. And at that point, Officer Kimbrough was terminated. So our contentions are, as I mentioned, the first one is that there was not substantial evidence. Now, I understand I've litigated this before, and that's a very difficult standard.
Right, because I know we talk about substantial evidence, but doesn't the law say that really the standard is any evidence?
Indeed, it does, Your Honor.
Okay.
The citation in our petition, it's a quote from the DeKalb County v. Bull. It says, the court must view the evidence in the light most favorable to the fact finder's decision and must affirm the decision if there's any evidence to support it. And again, that's the DeKalb County v. Bull, and it's in our brief. The city pointed to another case that's a newer case, but it says essentially the same thing and also cites to Bull. So in looking at this, though, I think we can make a contention that there was no evidence. And I guess the real point of this is there's no evidence that was provided by either the chief or the assistant chief, both of whom testified in the appeal hearing, on how they distinguished this from an arrest versus a detention. And usually the way it's determined is because of what happens at the end, right? But in this case, we never get there because, unfortunately, like I said, Mr. Holloman became unresponsive. The only policy violation that was held after the disagreement with the assistant chief and the chief was over this traffic policy. And when you look at the presentation to the board, the goal of the board should have been, I believe, to determine whether or not that policy violation existed and whether or not the city could make that case, whether or not the city actually made that case, because the burden of proof is upon the city. Under the city ordinances, and I have them as exhibits, we also had them in the record. I don't know if you want me to pull them up to look at them or not.
I know, because thankfully, because of, in I think recent years, the municipal codes have become much easier to access. And so there are actually databases that the court can access when y'all give me citations to them. So I appreciate that you attach them. It does make it easier, but I can also access them independently as well. So
Yes, Your Honor. And we made sure and sent certified copies so that you could take notice of them.
thank you, sir.
But Code Section 114.528, it basically says that the police chief is the one who has the authority to dismiss an employee. You also find that in Section 98-28. But even though the chief can do that, it still must be for cause. It can't be arbitrary. It can't just be for whatever reason they choose to. There has to be cause. And there's a laundry list of causation that's listed out in the ordinance. So in its case for the Civil Service Board, again, the city who had the burden to prove that the dismissal was indeed for cause, they put up both Chief Tyus and Chief Shearbaum as witnesses. And in order to affirm the termination, as I mentioned, the board needed evidence from the city to show that Kimbrough had violated the policy that he was terminated for. In essence, what evidence did either the assistant chief or the chief possess that would have caused them to conclude that the incident was in fact an arrest and not a detention, as Officer Kimbrough had stated in his OPS investigation?
So in terms of what Chief Shearbaum would have had access to the APD in making its decision at the OPS level, that would have included, I mean, I'm assuming there was I know there was body cam because I think I've seen some of the altercation on the news at whatever point, just as a regular citizen watching the news.
Yes, sir.
So I would assume that there would have been body cam footage and officer reports of this incident, right? So they would have been informed about the circumstances, correct?
Indeed, they should have had access to the entire OPS package, which should have included all that.
Okay, and so it is the primary issue that then Chief Shearbaum exercised. I guess what I'm trying to get to is the issue that Shearbaum looked at those facts and determined this is a policy violation, but that perhaps other reasonable people could look at it and see something different. And if that's the distinction, then doesn't the doesn't the balance weigh in favor of the decision of the chief?
Your Honor, excuse me, I don't believe so. And the reason I say that, so there certainly is an opinion involved, right? But the idea that he can only be dismissed for cause does require some, proof of causation and not just a personal opinion. So the matter becomes, what evidence was there that the chief relied on, or that the assistant chief relied on, to show that this was in fact an arrest versus a detention? Because it's a very important question. It establishes the difference between a policy violation versus something that's permissible. It's the difference between whether he can be terminated for that versus whether or not he keeps his job.
But
So-
isn't the only reason that the distinction between detainer and arrest exists at all because of the rights that the level of scrutiny that is applied to an officer's interaction with an individual, and the rights that might inure to the benefit of the individual that is interacting with the officer? And given that we're not in that circumstance,
Sure.
does the distinction between a detainer and an arrest matter legally?
So I think it does matter, because that's where the policy violation lies. If there's no arrest, there's no policy violation. And I do understand what you're saying about that distinction and the reason for its existence, but I think there's other reasons for that as well. I mean, there's the need for officers to understand where the bounds are, what they can do, what their causation has to be, reasonable suspicion versus probable cause, what their actions after the fact have to be. So I think there's a multitude of reasons that standard exists. But here, I think that standard is incredibly important. It should be a factual determination, and there should be some reason to point to why you determine one way or the other when his job depended upon it. If it's just semantics, then where's the due process anyway?
Does the internal policy that talks about requiring supervisor interaction, right? I'm assuming it's a part of a larger policy that directs the behavior of the APD officers. Does it include a separate or distinct discussion or definition of what is a detainer? What does it mean to detain someone versus arresting someone?
So it's not part of our record here, but Your Honor, I believe that it does. I believe they have a separate arrest policy, which I believe does discuss detention as well. In fact, one of the issues that I have with this is you have a policy in the traffic policy. That's the larger encompassing policy where this policy appears, that discusses all kinds of things to do with traffic, and it mentions this issue of arrest, but then it never really ties that back into their arrest and detention policy. I mean, is there some issue between those two where you could classify something as a detention under one policy, but here it's going to be viewed as an arrest. But to answer your question, I'm sorry I got off on a bit of a tangent, but I do believe that policy exists.
Okay, thank you.
May I continue, Your Honor?
Oh, yes, I'm sorry.
That's all right.
That's why I said thank you. You answered my question, so please go
That's
ahead.
all right. So, and on that question, if you look at the testimony that's recorded in the transcripts, I can quote some of it specifically if you like. If you look at their testimony in the transcripts, either Chief Tyus or Chief Shearbaum could say exactly what it was that caused them to make that distinction. If you look at Tyus's, he in essence says, well, I've been around a while and I see this, and it's not a detention here. It reminds me of a parent telling a child, well, it's because I said so, right? When you look at this, just reading a little bit out of this, he talks about what he would do as far as whether detention's proper, but he doesn't really go on to discuss in any further detail of why in this particular circumstance he believed this to be an arrest and not a detention. One of the things he mentions, this is in our current Exhibit 10. Like I said, I put a lot of exhibits in to make it easier instead of parsing through the whole record. It's his transcript on page 7. He says, and immediately during that interaction, I think there's a statement by Mr. Holloman asking for a supervisor, and former Officer Kimbrough's response was, I'll give you a supervisor, but you're still going to sign this ticket. Chief Tyus, in further recounting the video, recounts in the video, Officer Kimbrough, and this is a quote, tells him, you're going to sign this ticket or I will take you to jail. Now, he establishes that as part of his reasoning, I believe, for saying it's arrest. But then he also acknowledges later in his testimony, it might have been a cross-examination, that the explanation to someone who's not signing a ticket that the result is going to jail is actually part of the policy. So, because he said that, that's just his opinion. He said that doesn't look like an arrest. I'm sorry, it doesn't look like a detention.
What about, so here, in the interest of candor, I think it's important.
Yes.
I mean, because as a judge, I routinely am called upon to make judgment calls about whether something is an arrest or whether it's a detainer.
Indeed.
And I have a general walking around understanding, which is of what the general legal concepts are of a detention for further investigation versus an arrest. And that's one of the reasons I asked if there was a definition or other references in the policy to detainer versus arrest. And I guess, what evidence would you point me to about the point where, I believe, if I recall correctly, the evidence is that at some point Mr. Holman was being very disagreeable and disrespectful, et cetera, to the process. And at some point, Officer Kimbrough placed his hand on Mr. Holman, and then and that seems to be where the interaction escalated that ultimately resulted in the use of the taser. And I guess my question is that what is the testimony about when Officer Kimbrough physically put hands on Mr. Holman, and what effect, if any, that had on whether it was an arrest or a detention at that point?
Thank you, Your Honor. And that's an excellent point. And we raised it in an examination with, I think, with both Chief Tyus and Chief Shearbaum. But from the legal standard, you can certainly detain somebody. You can handcuff them. You can even use force against them if they're resistive in the course of a detention. We noted some of the case law during the examination, and that was admitted to both Chief Tyus and Chief Shearbaum. They both indicated in their testimony that yes, you can use physical force in a detention. You can put someone in handcuffs in a detention, and that's what I think makes this so difficult, because it's not readily apparent from the outside whether it's an arrest or detention. It really falls upon the intent of the officer and kind of what the final result is, which we don't have here because of how the events finally played out.
Thank you. You can go ahead. I appreciate that.
All right, thank you. So I think that is a good summary of Tyus's testimony. I did want to mention Chief Shearbaum's testimony a little bit, because it actually is important in our second contention as well. So our first contention is that they didn't provide any evidence for the board to make their decision based upon. The second one is that the board abused their discretion, and these two things are somewhat tied together. So again, if you look at Shearbaum's testimony, he didn't really fare any better in trying to provide an explanation for how he determined this was an arrest instead of a detention. And there's an exchange. It's in the transcript. It's our Exhibit 10. And I want to read a little bit of this. I won't read much of it because I know you've read the record and I don't want to bore you, but I do think it's important. So the chairman, cut to the chase here. They specifically asked, did he document why he made a change, why he disagreed with it? And he said that he didn't. Picking up, it said, so this is Chief Shearbaum. So there's a form that's completed at the very conclusion of the process that allows for it to come out the change in what the discipline will be. I can't recall right now. Mr. Wofford, if I wrote there why my position was of sustaining and proceeding with the dismissal, of the performance of directives. I can certainly give more detail if my answer wasn't satisfactory to Sackett's question. But I don't believe there's anything in writing for my final decision other than the fact that there's a policy that's been violated and there's been a death of a citizen at the conclusion of that policy violation. There's a direct link between, there's no variation or anything else factors that would have caused my decision to be otherwise. So he states it as a conclusion. It's a very conclusory statement that he states that the policy had been violated. Under cross-examination, he was asked, the question was, he, being Officer Kimbrough, had the authority to detain him physically, correct? And he responded, and he proceeded with an arrest, sir, which isn't really an answer to the question. His next question, do you recall Officer Kimbrough repeatedly stating that he made a decision to detain Mr. Holloman until a supervisor could get there? Answer, sir, I remember him telling him he was going to jail, is what I recall. And again, I point to the fact that the policy actually requires that. The next question, and he told his internal affairs he made the decision to detain him, correct? Answer, that's what he told internal affairs, sir. I saw an arrest taking place and I watched the video. Again, no explanation of why. Well, a detention and investigatory detention can also provide for someone to be physically restrained and handcuffed, correct? Answer, correct. But that's not what occurred here without further explanation. And one more, and I will leave this line. And just the fact that he was physically detained and handcuffed does not turn this into a full-blown arrest, does it? Answer, yeah, but it's not what occurred here. Again, without any explanation of how he made that determination. So no evidence really provided to show why this was an arrest and not a detention from the city's witnesses. But then our next contention, and I mentioned they're connected, is this idea that there's an abuse of discretion. So that standard, we talked about standards with the evidence rule. I pulled from Glover v. Atkinson Sneed. That's not in our brief. It's 348 Georgia Court of Appeals 679. It's a 2019 case. But they set out a standard for an abuse of discretion. They said, and I'm quoting, such an abuse of discretion occurs only where the trial court's ruling is unsupported by any evidence of record or where the ruling misstates or misapplies the relevant law. So it's our contention that in this vacuum that was created by the lack of evidence from the city, that the board improperly placed themselves in the shoes of the chief to find a violation on their own. They cite to City Ordinance 114-527, but that particular ordinance is only applicable to the chief. The board has no authority to use that ordinance to make any kind of determination of discipline. If you look at that particular code section, by its language, you look at this as statutory construction, it's clearly applicable to the firing disciplinary authority, which in this case would be Chief Shearbaum. And the very introduction of that section reads this way. It says, prior to application of any disciplinary action permitted by this division, the following shall be met. Well, that sentence in and of itself says it only applies to the chief because no one else under the city code can take disciplinary action, certainly not the disciplinary action of dismissal. So that particular code section only applies to the chief, yet the board took that particular code section and instead did their own application to it. The code section, the section that they utilize is 114-527-2B. Hold on just a moment. It says, determination of appropriate disciplinary action. A reasonable disciplinary action shall be determined by considering relevant factors, including but not limited to the seriousness of the offense, whether the offense was willful and deliberate, unintentional, or the result of gross negligence in the employee's record of performance and conduct. So you take that code section and you combine it with the vacuum of the evidence that they didn't get from the chief, and you get this from the board, and this is straight from their decision. It begins on page 6 of their decision. They write this. I said, we had hoped that the record before us would include evidence that, as we understand, is normally required the termination of city employees with civil service rights. The police chief had, 1, promptly investigated the facts and circumstances of the incident before deciding on the disciplinary action to be taken, and 2, had determined the appropriate disciplinary action by considering relevant factors, including but not limited to the seriousness of the offense, whether the offense was willful and deliberate, unintentional, or the result of gross negligence in the employee's record or performance and conduct, City Code 114-527. So they directly cite the code section and they directly say, hey, we didn't get this from the chief. We know this is what we normally are supposed to get. We didn't get it. So that should have been the end of their inquiry. At that point, when they didn't have evidence from the chief, instead of applying the things that the chief didn't give them, they should have reinstated that. That should have been their decision at that point. But they go on to say, unfortunately, the record here does not allow us to extend any deference to the chief of police's decision. It appears that the chief of police simply concurred with the assistant chief's statement that he disagreed with the OPS finding. Then it appears they based Mr. Kimbrough's dismissal on no investigation at all, since the record contains no evidence of any investigation other than the one they apparently disagreed with. So they then take this and they run with it. They start analyzing all kinds of facts, things that aren't even, in my opinion, not relevant to this case, such as the cause of Mr. Hallman's death. He was not charged with any violation of use of force. Nothing to do with that is pertinent to the policy violation for which he was fired.
Well,
It boils down simply to whether or not he was trying to make an arrest without a supervisor. The board impermissibly proceeded to step into the chief's shoes by doing this. They went so far, as I read a moment ago, to explicitly cite this code section and then went on to evaluate those circumstances to determine if that termination is proper.
so
And
Mr. Davis, I think
Yes, ma'am.
one thing I'm confused.
oh, yes, Your Honor.
That's okay. I don't mind.
I'm an
One
old
thing-
Southern boy. I apologize.
I know. One thing I am confused about though is the board's assertion or characterization of this lack of investigation. And I guess my point is, if it's demonstrated in the record that the I can't think of his name right now, not Chief Shearbaum, but Chief,
Yes.
thank you.
Yes, ma'am.
That
Yes, Your
both
Honor.
of them reviewed the file and observed the body cam footage. Isn't that an investigation?
Your Honor, I suppose you could say that it is.
Okay.
I wouldn't deny that it's at least some basic investigation.
Minimal, but something. Okay.
Yes, yes, Your Honor. But again, no results from that investigation. Did they supply any reasoning for how they made the determination that they made? And then for the board to go into that and do that analysis when the chief didn't, we would argue that's an abuse of discretion. They're misapplying that ordinance to themselves. Now, there is some language in another city ordinance, and I think that the city produced it as one of their documents that says the board does have some power to investigate, but the power to investigate is very different than the comparison that this particular ordinance provides that says this is what must be done before discipline is administered. And it's the responsibility to show that of the chief. And that didn't happen. And the board didn't hold him accountable for that. And that's dangerous in a number of ways. Certainly it's dangerous to my client, but it's also dangerous moving forward. If the board's allowed to just cherry pick an ordinance and say, hey, we can do these things because we didn't get the information that we should have got from somebody else, that really harms the process, I think. So I firmly believe that by them stepping into that role and analyzing all of these other factors, that's not their role to analyze, is a clear abuse of discretion. And for that reason, we would ask that you reverse it. And then our last contention is that there is an erroneous legal conclusion, right? They come to a conclusion, and it's really kind of disturbing, actually. They come to a conclusion that's totally in conflict with the ordinances, and it has to do with what they can do in a finding. Well, the city ordinances, it's I believe it's one. I'm sorry. I have papers everywhere. My apologies. I believe it's 114-553. Can you double check on that? But in that ordinance, it says the board can reinstate an individual. It says that they can instead, obviously not reinstate them in a firm determination, or they can modify a dismissal, and it is particular to a dismissal, to something that is not less than 30 days. And the board's done it before. One of the exhibits I submitted with our petition was another case that I had before the board. The board reinstated the employee and instituted a 90-day suspension. So it's certainly not outside of the scope of the ordinance, yet the board thought that it was. And I'm reading from their decision again. I believe this is near the last page of the decision. It says this, it says, we are, however, more constrained than the police chief in reaching a final disposition on weighing these factors, talking again about 527 that we just discussed. We have three choices: affirm dismissal, reinstate Mr. Kimbrough with no sanction, or modify the dismissal to no less than a 30-day suspension. City Code 114-553. Council, we understand from the board's legal counsel that the last option does not permit a modified suspension of more than 30 days. On balance, we're most influenced by the intentional nature of Mr. Kimbrough's violation, the intentional manner of his arrest of Mr. Holman, and Mr. Holman's increased susceptibility to injury or death. A 30-day suspension seems entirely too lenient a response to an outcome that almost certainly could have been avoided had Kimbrough chosen to follow the SOP. So there's a hint in their order that had they believed that they had an option to invoke a different, a longer suspension, they may have taken it. Now, I obviously can't sit here today and tell you they would have. I don't know. But the fact that they had a clearly erroneous understanding of that law and didn't believe that they could, I think that clearly taints their decision. I think that raises an issue that because of their misunderstanding of law, that could have been a detriment to my client. So that is our three contentions on appeal and my explanation for them. And if you have any other questions, happy to answer.
No, I think I have been interrupting you as you've been going, and you have been answering my questions, so I appreciate that. So what I'm going to do now is hear from Mr. Prothro, but it is your motion / petition. So after I'm done hearing from the city in terms of their response, you will get the last word because it's your motion. Okay, sir?
Thank you, John.
Thank you. Mr. Prothro.
Thank you, Judge. I'm going to take this slowly if the court will allow me. There's a lot to read here, a lot to digest. It's a very large file. But I wanted to start out by just giving an overview of the city's position. The city's position is that the Civil Service Board did not abuse its discretion and that its decision was made based on substantial evidence. I do believe that petitioner, was that me?
Nope, but if you're not talking, in other words, if you're not me or Mr. Prothro, if everybody could mute, that'd be awesome. Thank you.
Petitioner did file their writ for certiorari under the new certiorari laws found under the Superior and State Court Appellate Act, OCGA 5-3-1. And 5-3-5 lays out the obligations of the court, Your Honor, which I'm sure you've heard before. They are to review only matters raised in the record of the proceeding in the lower judicatory, accept the findings of fact and credibility of the lower judicatory unless they're clearly erroneous, accept a decision regarding an issue within the sound discretion of the lower judicatory unless such a decision was an abuse of discretion, and to determine whether the final judgment was sustained by sufficient evidence and review questions of law de novo. Counsel mentioned the case of DeKalb v. Bull, which is 295 Georgia App 551, for the proposition that the court must view the evidence in the light most favorable to the fact finder's decision and must affirm the decision if there is any evidence to support it. The DeKalb County or the Bull case actually goes on to say a little bit more than that, Judge, and if you'll allow me to share my screen,
Sure.
or I can just read to everyone. Let's see. Here it is. Can you see the case law, Judge?
I do.
Okay, great. So the court holds that the appropriate standard of review to be applied to issues of fact on writ of certiorari to the Superior Court is whether the decision below was supported by any evidence, as we articulated before. The court goes on to say that on appeal to this court, the Court of Appeals, our duty is not to review whether the record supports the Superior Court's decision, but whether the record supports the initial decision of the local governing body or administrative agency. And they cite to Glass versus City of Atlanta, which I'll get to in just a minute. Neither the Superior Court nor this court, again, the Court of Appeals, reweighs credibility determinations of the fact finder. In other words, because the fact finder in the initial proceedings is charged with weighing the evidence and judging the credibility of the witnesses, the Superior Court and this court must view the evidence in the light most favorable to the fact finder's decision and must affirm the decision if there is any evidence to support it, even when the party challenging the fact finder's conclusions present evidence during the initial proceedings that conflict with those conclusions. And again, they cite to Glass versus City of Atlanta. The reason I bring that out, Glass versus City of Atlanta is an appeal from the Civil Service Board. And the parenthetical says that although the petitioner, and let me read the cite, the citation for Glass versus City of Atlanta is 293 Georgia at 11. And it says, the parenthetical says, although the petitioner presented evidence to the Civil Service Board that conflicted with the city's evidence, the board was authorized to discount the petitioner's evidence, to find the testimony against the petitioner to be more credible, and to affirm his termination. Thus, because there was evidence to support the termination, the Superior Court did not err in affirming the board's decision, and this court affirmed the court's decision. That case involved a use of force allegation against a police officer that was terminated by the police chief. Now, that brings us to, Your Honor, Respondents Exhibit 1, which I've already submitted to the court, and I want to confirm everyone has that. It was filed with the record yesterday.
I do have, hang on, I'm pulling it up in my email right now, but yes, I did receive a package of documents that the city intended to present. I'm just
And I'm
trying to
prepared to share it
find it in
again.
my email. Yes, sir.
I can share it again if that'll make it easier for the court.
Thank you.
But let me move the little screen thingy. Okay. City of Atlanta Code Section 98-28 is the hiring and firing authority sections, qualifications of the chief. It applies to the chief of police as well as chief of the fire department. And subsection A says in the highlighted portions that the police chief is the hiring and firing authority for the Department of Police, subject to applicable ordinances and rules and regulations. And of course, there are more rules that opposing counsel has already brought up, and I'll get into some of those as well. In particular, under Respondents Exhibit 3, we get into the statement of policy for the progressive discipline of a city employee. And progressive discipline states is the policy of the city to impose where reasonable progressive discipline according to procedures that are fair and prompt and appropriate for the situation. However, when an infraction is such as to impair or destroy the future effective performance of the employee, or when the employee's presence impairs the effectiveness of others or presents danger to the employee, others, or city property, action shall be taken to immediately remove the employee from the work environment. And I bring that up only to say that there are some exceptions to the progressive discipline policy, and they are embedded throughout the discipline.
Well, but let me ask you, Mr. Prothrow, and if I've overlooked it, please direct me to it, but I'm not aware of the record containing a statement by the chief or others saying we're relying on section 114.526 to say that we just summarily were authorized to remove Mr. Kimbrough.
That's correct, Judge. I haven't seen that citation as well. That will bring me up or push me a little forward in my argument. At the end of the day, at the end of the CSB hearing, the board actually did not give deference to Chief Schierbaum's testimony. And as we all know, deference is the practice or legal practice of giving credibility to someone else's fact finding or determination. The board took it upon themselves to do their own investigation in looking at the record. And I think the court asked the question earlier about wouldn't Chief Schierbaum and Assistant Chief Tyus's review of the OPS files and review of the video be a form of an investigation? And I believe the court was on the right path. I believe that is correct. It would be. But the CSB at that point also reviewed the video themselves. If you look in the transcript, they actually reviewed the video and they went to great length in their report to describe what they saw and how the things they saw affected their decision making. And actually, let me jump to that now. The board, to go to our first point that there was substantial evidence, the board lists that they reviewed 12 exhibits submitted by the city at the CSB hearing, 30 exhibits submitted by Mr. Kimbrough. There were testimony of witnesses listed. They actually requested additional information, which included the autopsy report for Mr. Holman, which I think opposing counsel was referencing earlier. They requested information and received information on the use of conductive electric weapons, tasers, that type of thing. But essentially what they tried to do under their standard of decision section of the report, and I think the report speaks for itself, they tried to keep the analysis as close to the same analysis that would be applied by the appointing authority. And in doing this, they assumed the role of the investigative body by using their authority under, let me find that code section. I believe there's a city code section 114-548. Let me pull that up. So under City of Atlanta Code section 114-548, civil service board members serve as hearing officers for disciplinary hearings when an appeal is filed from an adverse employment decision. And it says, for the purposes of holding hearings of appeals as provided in Article 4 of this chapter, and otherwise assisting in the resolution of appeals under this article, the Civil Service Board shall serve as individual hearing officers. In a dismissal, a panel of 3 board members shall be convened for the purpose of the hearing for the dismissal, notwithstanding any other authority and duties given to the Civil Service Board as individual hearing officers. They shall compile evidence, prepare findings of fact, issue initial decisions and the basis therefore, certify records, and make investigations of matters under the jurisdiction of this article where a review is appropriate. So once they determined that they were not going to give deference to Chief Schierbaum and Chief Tyus's testimony, they were able to then do their own investigation as to whether they believed or whether the evidence supported a finding that Mr. Kimbrough violated the city standard operating procedures that should have been imposed or should have been in effect at the time that he was issuing that citation. Let's see. Additionally, under section 114-553, under subsection B, finality of decisions, it goes on to say the decision of the hearing officer panel shall be binding on both parties. For appeals of adverse actions, the hearing officer or panel may modify the action of the appointing authority, but may not increase the severity of the action. And I think this gets to opposing counsel's error of law argument, but I think it also supports our argument because it does talk about the authority that the hearing board has to modify the decisions of the lower appointing board, of the lower appointing authority. It says if the appellant is a non-probationary sworn officer of the Department of Police who holds the rank of lieutenant or below, or below that of lieutenant, or a sworn officer of the Department of Fire who holds the rank of captain or any rank below that of captain, the hearing officer panel may not modify, but may affirm or revoke a suspension or demotion and may affirm, revoke, or modify dismissal to no less than 30-day suspension. So they can change the decision. They can modify the decision, the OPS decision that was presented to them. In this situation,
sorry, Mr. Purther.
Yes,
What though about Mr. Davis's argument that that statute, that the Civil Service Board committed an error of law in interpreting that statute to say that they only had 2 choices? They could adopt or accept this discipline that had been imposed, or do a 30-day suspension and nothing in between?
Your Honor, I believe that if that in fact is an error of law, I think that may have been harmless error. Based on the report that they provided in total, it is clear to me at least that the board seemed to believe that the actions by Mr. Kimbrough were egregious and did not follow the normal standard operating procedures for the city of Atlanta. And they did take into, and when they did their analysis, they were specific in that they were looking at the totality of the circumstances. And so in that respect, the outcome was something that they looked at, that someone did lose their life in this situation. This is not like the situation, I believe, opposing counsel presented a similar CSB case involving a firefighter, but that was a dismissal, I believe, over a teaching incident or an instruction. This is completely different because this actually involved the loss of life of a citizen due to the failure on behalf of Mr. Kimbrough to follow the standard operating procedures and to seek an on-site supervisor. And the SOP is very clear in that. The SOP states that the officer will have the violator sign the citation to only acknowledge receipt of the citation and awareness of the court date. If the violator refuses to sign the citation, the officer will inform the traffic violator that signing the citation is not an admission of guilt and that failure to sign may result in a physical arrest, requiring them to post a cash bond to ensure appearance in court. And that's to comply with state law, which was OCGA 40-13-2.1. A physical arrest for refusal to sign must be approved by an on-scene supervisor. The officer will write refuse to sign in the signature space and charge the violator accordingly. The whole purpose of that, and the CSB went to great lengths to discuss that in their report, was to create a cooling off period to allow the officer time to give the citation, but to give the citizen a chance and the officer a chance to cool down before an arrest was made, because we know that arrest can be a very stressful situation. That didn't happen in this situation. In this situation, Mr. Holman repeatedly requested that a supervisor or a sergeant be dispatched out because he disagreed with the ticket. Instead, he was told that he would only get the supervisor if he signed the ticket first. And that is not in compliance with the SOP. The SOP clearly says that before the physical arrest can be effectuated, a supervisor has to be on site and they have to approve the physical arrest. I don't know if the court is inclined to watch the video. I do have the video cleared up. It is quite graphic. But in the CSB report, they go on to mention the number of times that Mr. Holman requested a supervisor or sergeant, the number of times that he was told, and let me see if I can find that. They went on to say that first, no evidence, Mr. Kimbrough's assertion was that this was a detention. And the CSB looked at the facts that they gleaned from the video to determine if it justified a detention. One of the first things they said is, first, no evidence suggests that Mr. Holman was attempting to flee or that Mr. Kimbrough believed Mr. Holman was attempting to flee. Before Mr. Kimbrough arrived, Mr. Holman had called 911 to report the accident. He then surrendered his driver's license to Mr. Kimbrough. Mr. Kimbrough expressed no concern about Mr. Holman's possible flight on the body-worn footage and did not cite that possibility during his OPS interview as a reason to detain Mr. Holman. Most important, nothing in our review of the body-worn camera footage even remotely suggests that Mr. Holman intended to leave the scene. So they addressed the fact that perhaps he was going to leave and therefore he needed to be detained. And based on what they said, based on what they saw, they didn't feel that the video footage justified a detention. They also said that the preponderance of the evidence suggests no imminent threat of harm to Mr. Kimbrough or to the public. And it says that during the first few seconds of the encounter, Mr. Holman complied with Mr. Kimbrough's request. He surrendered his driver's license. He separated himself from the other person. He made no threats verbally or physically to either Mr. Kimbrough or the bystanders. And Mr. Kimbrough seemed to concede as much during his OPS interview, stating that Mr. Holman was completely avoiding any contact with me. They go on and on and on and in their analysis of the video. And the reason that I bring that up, Judge, is their independent review of the video shows, again, that there was sufficient evidence for this ruling. But their authority to do an independent fact finding under Section 114, I think it was 553, shows that even though they give no deference or little deference to Chief Schierbaum and to Assistant Chief Tyus, they themselves still did their own investigation into the evidence presented before them. And I think the most important evidence that was presented before them after giving no deference was in fact the video itself. And they very thoroughly examined that video.
But I mean, I understand your position is that the CSB has some authority to review materials, et cetera. But Mr. Davis's characterization is that essentially the CSB said, we don't have any evidence in front of it. So it created its own record and did its own investigation and made a decision. And that exercise was in fact an abuse of the discretion that is imbued to the CSB.
Your Honor, I believe that based on section 114 dash, let me get my notes again, 553.
553. Okay.
Yes, 553. Thank you, Judge. Section 114.553 requires the board to issue its own findings supported by the underlying evidence. I believe that code section requires them to do their own fact finding and their own investigation. The CSB is not supposed to just rubber stamp the decision from the police. They are supposed to do their own independent investigation, and whatever determination, whether it is for the police or for the city or against the city, it is binding on the city. And so its ability to bind the city by its investigation or determination does imply, Your Honor, that it can conduct its own fact finding. It doesn't simply accept evidence and then rubber stamp it based on the opinion or the recommendation of the party that presented that evidence. It has to weigh it itself. And in weighing it, it determined that based on that video, it did support Chief Schierbaum's and Assistant Chief Tyus's recommendation, and it too disagreed with the OPS finding. Can I go on?
Yes, please.
Okay, thank you. Okay. And I believe it's under subsection B of 114-553 that states that the decision of the hearing officer panel is binding on both parties. And again, I think that is implicit in the ability to bind the parties would be to have to do your own investigation, your own determination of facts, and to review the facts independently from the parties. Otherwise, you wouldn't be able to bind them. You would simply be a rubber stamp to those parties.
Well, I guess what I'm trying to get to is everybody is bound by what I say, right? But nobody expects me to go and say, hey, some entity, give me this evidence so that I can review it. I rely on the parties to present that evidence. And I think, as I understand Mr. Davis's argument, it's that the city didn't put any evidence in front of them on those issues. And so the board sort of undertook its own independent, give me this evidence so I can review it, as opposed to merely reviewing evidence that was provided to it.
The board did review the video which was presented to it.
Mm-hmm.
The board did do a credibility determination on Mr. Kimbrough's testimony.
Mm-hmm.
The board did hear evidence or testimony from Chief Schierbaum and from Assistant Chief Tyus. And so to that extent, Your Honor, there was evidence presented to it that it didn't go out on its own and get. Now, to the
But
extent
the
that they
information
were,
about the autopsy report, the information about the effect and use of tasers, I mean, that was clearly outside of the case, for lack of a better way to put it, that the APD had presented.
yes, Your Honor,
To
I was
support
just
its
about to say,
decision.
yes, Your Honor, I was just about to say, to the extent that the board requested additional information and received the autopsy report, received the CEW studies and data, that was outside. The city will acknowledge that, but that was outside of what was presented on the date of the hearing.
Does that fact change? I guess my question is, your position is that they had the authority to do that. And so it was okay for them to take into consideration any of that? Or is it that even if they were not authorized to obtain that information and take it into account in making their decision, that the decision would have been the same even without that information?
I think their decision would have been the same even without that information. I see that information as a request for reference information, not new information underlying the facts of the case. The information on the conductive, the CEWs, the information on the cause of death.
Is that a taser?
That's
A
a taser.
CEW? Okay,
Yeah,
thank
I
you.
think, what is it, a conductive electronic weapon or something like that? That is a taser.
Okay.
And that
I
information.
guess taser is a brand name, so.
I think taser, it may be, I don't know, Your Honor.
I didn't mean to distract. I apologize. I just had never heard the phrase CEW, so.
I always assumed it was similar to laser, which I know is an acronym, but
Mhm.
after seeing CEW, I'm not so sure. Perhaps it is like saying Coca-Cola is a brand name.
Mhm.
But to the extent that they receive information on how tasers deploy, how they affect the body, I think that was reference information to guide them in their decision on the information that was presented and that was available through the video. It was disclosed during the testimony that Mr. Holman's death was a homicide, but that's a medical determination, meaning that it was at the result of someone else's hands, not due to natural causes. So again, getting the autopsy report, I don't think provided them any information other than specifics of forensic specifics. I don't think it provided them any information they did not already have. As far as the error of law argument, Judge, I do think that I would argue that is harmless error, because I don't think in the totality of the circumstances, the board, and again, I'm speculating, and my position is that plaintiff's counsel or petitioner is speculating as well as to what the board would have done, but I don't believe that they would have ruled any differently given the nature of the offense and the totality of the circumstances that this did result in the death of a citizen.
Thank you, Mr. Prothero.
And so for those reasons, Judge, just to summarize or just to wrap it up in summary, we feel that the board did review the evidence thoroughly, that there was sufficient evidence, an abundance of evidence, if you will, for them to review, and that their failure to give or refusal to give deference to Chief Schierbaum and Assistant Chief Tyus and to do their own investigation is permitted under the code sections, specifically under City Code 114-553, and it's implied in some other code sections. And I do believe that as far as petitioner's contentions for the error of law, that was harmless error, that given the totality of the circumstances, the same decision would have been made, but they were not allowed to explore they did not fully explore all of those options. The city will concede that.
Okay. Question, Mr. Prothero.
Yes, ma'am.
If it was an error of law, right? If the board was incorrect in its apprehension that it could apply any appropriate sanction short of termination, and the court were persuaded that it was, right? What is the outcome there? Does it get remanded to the Civil Service Board for them to reassess merely the possibility of a longer suspension, or does it undo the entirety of the case? Because it seems to me that the harmless error issue is one that goes to, the error of law issue is one that goes to, presumably, the way I think it shakes out, and I could be wrong, and if I am, that's why I'm asking the question, Mr. Prothero, that would assume that there was a basis to discipline Mr. Kimbrough, and that the board didn't abuse its discretion in determining that there was a basis to discipline, but merely that they made an error of law in determining the nature of the discipline that was available to it.
Your Honor, the city's position is that it would be harmless error and that the case should not be remanded, and that their failure to interpret the law as advanced by petitioner would not result in a change of the circumstances or the change or the outcome. Nevertheless, if the court disagrees, under OCGA 5-3-18, the court does have the authority to remand back to the lower judicatory with instructions, and the city would take the position that the instructions should be that the remand and reevaluation of the case should be limited to the issue of the appropriate punishment, the appropriate discipline.
Okay.
So
which in theory, forgive me for interrupting, but if the court were to do that, in theory, the board could still say, we think termination is the appropriate remedy. We just needed to clarify that we understood we could craft anything that would have been a legally allowable sanction.
That's correct, Judge. And that's
okay?
why our position would be remand with instructions if the court is not inclined to view this as harmless error. And I think the court is reviewing this de novo. So if the court is not inclined to review or to determine that the CSB's ruling was a harmless error and was in fact an error of law, the city would think that the appropriate measure would be, an appropriate measure could be a remand with instruction that it be limited to or just review of the disciplinary options available.
Okay, but the city's primary position is that the board that there was evidence, the board did not abuse its discretion or commit an error of law, and that the petition for review should be, excuse me, that the board should be affirmed on the petition for review. Is that correct?
Yes, Judge, that is correct. That is the city's position.
Okay, thank you, Mr. Prothro. Anything else?
No, Your Honor.
Okay, Mr. Davis?
So, Your Honor, I'm actually going to defer in rebuttal to my colleague here, Mr. Smart, to save my
Okay.
voice. I will make one comment, though. It's a harmless error is one that happens to somebody else, but I'll leave that alone. I appreciate your time. Thank you, Your Honor.
While we're making side notes, I will mention that I did look it up, and Taser is, in fact, a name brand of a CEW. It's sort of like Kleenex and tissue.
Got it.
So
Coke and
Anyway.
Pepsi. Okay.
learn something new every day. Mr.
Yes.
Smart, please go ahead, sir.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, I want to readdress a question that you asked Mr. Davis before, and that was, isn't watching body cam, could that be considered an investigation? I think that perfectly encapsulates why we're here today, because it should be, right? But there's nothing in that actual footage that provides an objective or provides objective evidence of an arrest rather than a detention, right? And the chief and the assistant chief made no note of that in reaching their decision. They didn't say, for example, this is what happened that makes this an arrest, or this, and that. They never mentioned that. And Mr. Prothro
Well,
mentioned,
but I mean, forgive me for interrupting, Mr. Smart, but I mean, this feels a little bit like the famous Supreme Court justice who said, I can't define pornography, but I know it when I see it. And I mean, I guess, is there some, if the chief of the police department is saying that was an arrest, I looked at that body cam and that was an arrest, isn't that enough? Why does he have to say it was a detention here and here and here, and then this thing happens and it becomes an arrest? Why is he required to say that?
well, Mr. Kimbrough needed to be dismissed for cause, correct? And essentially, when you recap Chief Tyus and Chief Shearbaum's testimony, you can see that they insert their subjective beliefs and frankly, what amounts to speculation rather than evidence. For example, Chief Tyus testified at one point that, and I quote, "I think Officer Kimbrough has made up his mind that he," referring to Mr. Holman, "is going to jail." Right? That's purely speculation. And that was before the board. He's testifying as to Mr. Kimbrough's mental state on that evening. Right? And he goes on to say that he doesn't think anyone who saw the body camera footage thought that Mr. Kimbrough was conducting a detention. Again, more speculation. Now, that further shows subjectivity because, again, Chief Tyus himself admitted that detentions can be accompanied by uses of force and placing the detainee in handcuffs. So there's truly nothing in that video that can accurately show that this was an arrest as opposed to a detention. Now, Chief Shearbaum testified that the direct result of this alleged policy violation was a death, and that there was an opportunity for that outcome to not have occurred had the policy been followed. And Mr. Prothro mentioned it. Some of the justification for that policy is the cooling off period that would give, in this situation, Mr. Holman and Mr. Kimbrough time to cool off. But again, who's to say that if a supervisor does show up, that Mr. Holman lowers his voice or calms down? It's pure speculation, and we're dealing with hypotheticals here, right? It's an entirely unpredictable situation. And to say that something would have gone differently had a supervisor arrived cannot be based on evidence, as this incident never reached that point, right? And so at that point, it's clear that the chief's final determination was not supported by proper cause, as there was no evidence at all. And reviewing the same factors as the chief would have, the board could not have determined that proper cause exists either, which brings me to my next point regarding the abuse of discretion. So in the decision, the board noted that it could not defer to the decision of the chief and assistant chief, even though they would have liked to, because, as they said, there was no, and I quote, I'm sorry, They based Mr. Kimbrough's dismissal on no investigation at all, since the record contains no evidence of any investigation other than the OPS investigation they disagreed with, or that the board did not, or that, excuse me, the chief did not leave the board with any findings with regard to their decision. So, seeing as they could afford no deference to the chief's determination for those reasons, the board took it upon themselves to consider relevant factors specified by City Code 114-527. Now,
If they are supposed to be an independent reviewing body, how is that outside their discretion?
because Judge 114-527 and those factors are reserved strictly for the chief of police. And to illustrate that, first I want to turn to 114-526B. That states, notwithstanding anything in this division to the contrary, the fire chief and police chief shall retain authority to administer corrective or disciplinary action. Now, looking back to 114-527, the section the board cited when reaching its decision, it begins with, prior to the application of any disciplinary action permitted by this division, the following shall be met. Okay, and it goes on to list that an investigation should be done. It enlists those relevant factors. The board went so far as to use those relevant factors that are reserved for the chief's discretion as headings in their analysis as whether the dismissal was proper or not. So while the board does have independent authority to utilize discretion and make a determination, they did not exercise that source of authority. They exercised the chief's source of authority and reviewed the factors that the chief was supposed to mention, including the outcome of the situation. And clearly that was on their mind when weighing the evidence. And I'm going to read from their decision. And I quote, on balance, we are most influenced by the intentional nature of Mr. Kimbrough's violation, the initial manner of his arrest of Mr. Holman, and Mr. Holman's increased susceptibility to injury or death. A 30-day suspension seems entirely too lenient a response to an outcome that almost certainly could have been avoided had Mr. Kimbrough chosen to follow the SOP. For this reason, we deny Mr. Kimbrough's appeal. So it's clear that they thought, and turning to the last argument, the error of law, that to impose something less than 30 days would be inappropriate, right? And so they could have imposed something more than 30 days. And they said in their decision that the city said in their answer that the board is entitled to rely on their legal counsel when there's an ambiguity in the code or the policy, and run with that interpretation. Now, my contention is that it's not very ambiguous in the policy. And even though the board is entitled to follow the interpretation of their legal counsel, that doesn't give the legal counsel the ability to interpret the law incorrectly. Right. And so, and the board again seems to suggest that had it been aware that a suspension of more than 30 days was a possibility, that it may have imposed such a penalty. So, Your Honor, seeing as the decision to dismiss Mr. Kimbrough was not supported by any evidence, that the board usurped the chief's exclusive power in exercising its discretion, and that the board made a clear error of the law in determining the most appropriate penalty, we believe that the board's affirmation of Mr. Kimbrough's dismissal must be reversed.
Okay, thank you, Mr. Smart. I would like to, so I'm not going to rule from the metaphorical bench today. I am intending, what I typically will do is take a look at the issues and probably advise what'll happen is you'll get an email probably from Mr. Freehoff that says Judge Krause is going to rule X and ask one side or the other to prepare a draft order. Mr. Smart, I hope you don't mind my saying so, but given your relative youthful appearance, I looked you up and it appears to me that you were just admitted to the bar. Is that right?
That's correct, Your Honor.
Congratulations, sir, and well done.
Congratulations.
Thank you.
And Mr. Davis, whether it's your voice or otherwise, I strongly congratulate you and appreciate you giving young attorneys an opportunity to make arguments to the court, because so often they have to stand in line behind the more experienced attorneys, and they're not going to, develop those skills without having the opportunity. So I applaud you for that, sir.
Thank you, Your Honor. He lives up to his namesake.
Excellent. Good to know.
Your Honor, may I make a request of the court?
Yes, sir.
I know that we've presented our cases. In hearing the cases, there's a question that's come up for me. I've heard petitioner side articulate that they believe that section 114, 526, and 527 are limited to the police. The city has a different police and I guess fire. The city has a different opinion. Would it be permissible for the parties to just send the court a letter brief on our position on that? Because I do feel like there are some things that were not said that I wish had been said, but I understand that both sides have said their piece, so to speak. Would the court be inclined just to have a short letter brief from both sides on that issue, or is?
What are your thoughts on that, Mr. Davis or Mr. Smart?
Your Honor, I think the language in the statutory construction is very clear. Certainly we can do a letter brief if you desire it, but I think the plain language of the statute speaks for itself. I don't know that it requires briefing, but that's a decision for you, Your Honor.
Hang on just one moment. And this is the one, Mr. Prothro, that you had up on the screen earlier, correct?
That's correct. I had it on the screen as Respondents Exhibit 3.
Yes, sir. Thank you.
Mhm.
Okay. And am I correct in understanding that the disagreement here is that the language here says the manager or supervisor shall investigate. And it seems like most simply Mr. Kimbrough's position is that means the chief of police. And the city's position is that means anyone in a position to make the decision about discipline, which would include the Civil Service Board here, since they were called upon to make that decision. Is that roughly accurate, Mr. Davis, from your of what your position is?
Your Honor, it is. Again, I mentioned the introductory language of that statute, which says no discipline shall happen unless these things are done. So it's clearly a preemptory, obligation. And the only person who can establish the discipline, especially a dismissal, is the chief. So I think it's clear from that construction that it only applies to the chief. It's intended to be preemptory, and it's a duty that the chief must meet, which he did not convey that he did.
Okay. And Mr. Prothro, am I correct in terms of what my characterization was, is that your position is that it applies more broadly to anyone with the authority to discipline an employee, which the Civil Service Board, I don't think anybody questions they have authority to do that.
Yes, Judge, that's correct. My position is that the code section itself is broader in application, and that there are provisions within that code section that are narrowly tailored to fit specifically with the police and with the fire chief.
Okay.
But in total, that it has a broader application. Yes, Your Honor. Okay.
So I think I am interested in a letter brief on that issue, Mr. Davis, and Mr. Prothro. And I'll tell you why, because just to give you some insight into sort of my thought process, the any evidence standard, we can continue to say substantial evidence, but all that does is confuse the issue. At the end of the day, it is an any evidence standard. And if the board had before it the body cam video and the narrative reports of what occurred, besides anything else, and that is any evidence from which they might have made a decision. I think it is a much more interesting question about whether the board was acting outside of its authority in terms of whether it abused its discretion in making a decision based on information that was provided to it at its request rather than by the city sort of presenting it. Now, I don't know. I think that that would be helpful to me because both parties have directed me to 114,527 and also 114,553. And I think it would be helpful to have a little bit more information from the parties about that discretionary act and the authority that the Civil Service Board has to act in that manner. And whether what they undertook, I think two things, whether what they undertook was outside of their purview and that necessarily constitutes an abuse of discretion, or if because there was evidence presented by the APD from which they could have made a decision without the additional information, that such a potential abuse of discretion might also have been harmless. I don't know the answer to that, but that is what I would be interested in. And by letter brief, you can do it any way you want, but I do not want you guys to like write me a treatise. 5 pages, maybe. And that's assuming like double space motion pages. Like if you send me a letter, I'm really looking at 3 pages or less. And reasonably, since this is top of mind for you guys, would it be possible to do a week from today, the 13th of November?
Yes, ma'am. I would be happy to do that.
Thank you. And so if we can do that, as I said, if you'll just email those, I mean, you can file them if you'd like to make them a part of your record. But the main thing is to send them to Mr. Freehoff so that I have the ability to review them. And then I will undertake to provide the parties a ruling.
And Judge,
Yes, sir, Mr. Prothero.
just to be clear,
Mhm.
would you repeat the respective issues so I can make sure that we research?
Yeah, so I think the primary issue, as I understand it, is that Mr. Kimbrough has argued that 114,527 requires the manager or supervisor to conduct an investigation and to make a decision supported by evidence, right? And I think I understand Mr. Kimbrough's position is that that means that that's what Chief Shearbaum had to do, or APD had to do, and that the Civil Service Board doesn't have the same discretion or authority to conduct an independent investigation. So my first question is, what is there to help me understand who's covered under 114,527? Because Mr. Prothero, you have argued that you have argued that the Civil Service Board is contemplated by 114,527. And I think at least facially, certainly the Civil Service Board is in a position to make decisions about termination and punishment. And so in theory, I could understand why there might be a basis to say that progressive discipline strategies apply to the Civil Service Board. But I don't know the answer to that. And I think it would be helpful. The secondary issue I asked Mr. Prothero was, I think I understood part of your argument to be, even if they brought in this extraneous information, right? The autopsy report and the CEW mechanics, that doesn't constitute an abuse of discretion and or it's harmless if in fact there was some evidence, which I've indicated, I think there likely was any evidence, that the activities undertaken by the board, even if they were an abuse of discretion, would not necessitate a different outcome. That's really what I'm trying to get to.
All right, I just want to make sure. Thank you, Judge.
Okay. Any other questions or clarification?
No, Your Honor.
Okay.
No,
The
Judge.
joys
I
of
keep trying to
Zoom.
coordinate here, so that
Yeah.
doesn't happen. I
No worries.
apologize, but thank you for your time, Your Honor.
No, absolutely. And I appreciate y'all being concise with your presentation and your time. I will look for that additional briefing on November the 13th, and I will endeavor to get you a ruling as quickly as I can. And we get busy. I know you guys are all very busy, but I I try really hard to give you guys a ruling within a couple of weeks. If you haven't heard from me in a couple of weeks, you are not going to hurt my feelings to email Mr. Freehoff and say, hey, what's the status of that? Because sometimes that's what it takes to get it back to the top of my pile again. And I don't want it to go too long. I pride myself on trying to be prompt with my rulings so that the parties aren't prejudiced by any delay while I was sitting on it. Okay?
Yes, Judge.
Okay. Thank you all. Have a very good day.
Thank you, Your Honor. Have a great day.
Bye-bye.
Counsel Davis, did you want a copy? I meant the original transcript.
All right, hang on one second. I could not hear you. I had was trying to get our sound taken care of. What can I do for you?
You're okay. Did you want the original transcript?
Yes, we do.
Okay, and Counsel Prothero, did you want a copy of the transcript?
Yeah, well, yes, we'll take a e-copy.
Okay, and the standard delivery?
Yes.
Did you want e-copy as well, Counsel Davis?
Please.
Okay, I am gonna email and verify who gets the original. There's a little conflict with scheduling. I'm pretty sure it's you, Mr. Davis, since y'all hired out, but I will follow up to let you guys know as well.
Let us know. We'll do whatever we need to do.
Okay,
Thank
Ken,
you.
nice to meet you.
sounds good. Nice to meet
Pleasure
you.
meeting
Oh,
you.
I do have
Miss-
two spellings. Sorry.
Okay.
The chief's names, could y'all spell those for me, please?
Maybe.
Schierbaum is,
SCH.
yeah, Schierbaum is SCHIERBAUM as in Mary.
Okay.
And was that it?
The other.
Tyus?
I think it's
Chief's
TYUS.
assistants. Yeah.
That's right, TYUS. Mhm.
Thank you.
All right.
Mr. Prothos, I did want to also mention, it's good to meet you. Michael said y'all been working together on something else. And I'm familiar with that. I appreciate that we can be on opposite sides on one thing and work with each other. That's a good thing.
It is nice to meet professionals. Thank you, Kim, for saying that.
Yeah.
Look forward to working with you guys. Oh, did Michael leave? I guess he did. He's emailed me a couple of times. I was just going to say hello to him, but there he is.
Sorry, I jumped the gun.
What was that? He was next to me.
I was just going to say, Michael's nice to put a face with the emails. I think you've emailed me a couple of times
Yes.
about another case.
Correct. Yes, you as
involving-
well.
Yeah, nice to meet you. And congratulations on just getting admitted.
I appreciate that. Thank you.
All right, thank you. Take care, guys. Have a great
We're
day.
lucky to get him.